Leaders Live, where I get the chance to chat with luminaries in e-discovery and related areas.
Welcome to e-Discovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha, Senior Vice President of Brand Awareness at Reveal. Each Friday morning at 11 a.m. Eastern, I host an episode of e-Discovery Leaders Live, where I get the chance to chat with luminaries in e-discovery and related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select Resources, then select eDiscovery Leaders Live. My guest this week is Christiane Müller-Haye. I think I got that right. Christiane is currently the Regional Technical Director for Continental Europe at Clifford in Frankfurt, Germany. She is a member and country representative Europe for the Global Legal Tech Consortium and a border and social media director for Women in E-Discovery, the Frankfurt chapter. She's held positions in the past at Moray, Phoenix Business Solutions, Rowe Consulting, Ipona Deutschland, and Hengler Müller. Christiane, welcome, and thanks for joining us today.
Thanks, George. So I'm bringing the sun today into the session, the afternoon sun in Frankfurt. Thanks for having me.
You are truly enlightening us.
Yeah, and I try to move not too much into the light. So
that is okay. Well, there are a number of things I want to ask you about today, in particular because you bring a perspective that we haven't really had much of in past episodes, that of someone in Germany. And that, of course, means as well a focus on GDPR. So I'd like to start there and get your take on GDPR, what it means, and what its impact is with respect to electronic discovery.
Well, GDPR obviously imposes a host of enhanced obligations on anyone, a corporation, legal teams, etc., who is collecting and processing data. And it also provides data subjects with a greater control over the use of their personal data. That said, in Germany, we mostly rely on in-country processing and hosting along with pre-filtering to definitely exclude a data privacy violation transfer to a third country. Yeah, so we really need to engage with local resources to process on local data, resources like ourselves maybe, who understand or who respect the local data privacy restrictions we have, which become stricter due to GDPR.
I think even before GDPR, in Germany, you had perhaps the most restrictive, if not some of the most restrictive data privacy restrictions of any country, no?
Yeah. I mean, that the old and the new world of GDPR, they are. I mean, there's some elements. It just increased, and especially focusing on personal data of data subjects, really, that emphasizes even more on that. But I mean, the Germany and our neighbors in Switzerland, that is always causing, and it's not causing a headache. Obviously, there are solutions to deal with it, but they are probably the most strictest data protection laws in the world. Yes.
Because most of the e-discovery activity globally either takes place in the US or is a result of US-based litigation or investigations, I assume that means that quite regularly you are in a situation where someone from the US wants data out of Germany, and you've got some explaining to do. How does that scenario play out?
Well, yeah, I mean, so what can typically come from the US, yeah, previously working at an e-discovery consultancy at Moray, yeah, is that something like just go ahead and collect the data, send it over to us, and we look after it. But this is not going to work here in Germany like this. No, I mean, it probably worked out in some ways, but the days where international legal advisors could prioritize the free movement of data around the globe to best fit their strategies and resources over current day compliance regulations that now exist on the very movement of data, they are gone. Yeah, they are really gone. But unfortunately, obviously, even today, European enterprises continue to allow the unfiltered and unprocessed transfer of data in jurisdictional proceedings outside of the scope of GDPR, and despite the existing penalties that exist.
So I guess that takes us in two paths. Let's focus a little bit on GDPR first and then move to what you were just talking about there. For GDPR, what do organizations that are based outside of the US, I mean, based outside of Germany and based outside of Europe, but potentially subject to GDPR requirements, need to know vis-a-vis what's happening in Germany? I mean, does it matter to them? Where do they fit?
Well, I mean, in addition to the protection of the personal data I was more talking about at the start of our conversation, there is obviously some considerations around export control to consider, banking secrecy, intellectual property protection, and other GDPR governed data. And for example, we as law firm are asked more than ever, and also, I mean, every e-discovery provider. You see the sun is going away now. Very nice. Sorry. And I mean, even we are even more asked to advise our clients, or the providers are asked to advise their clients and their legal counsel on the meaningful, robust, and secure methodologies available today. Yeah, so that's something which is not just about PII. There's more to it. Yeah, a lot of laws which are covered or governed under the GDPR, which we consider.
So what would it? So I'll describe a scenario and help me understand how this would work out. Let's assume there is a major lawsuit based in the United States brought against a substantial corporation with operations around the world, including research and manufacturing facilities in Germany. And the corporation's the defendant. The plaintiffs want information about what happened in that research facility, the research work done, and they want information about what was done in the manufacturing facility. So they put together a set of requests. They ask for A and B and C and D and so on. The American lawyers go, well, that's easy. We're just going to go ask for that the way we always do. And then they come up against the restrictions in place, not just with GDPR, but the other privacy regulations. this may be the first time they've encountered something like that. I know that continues to be the case with a number of lawyers here. How do you advise them? What do you suggest to them that they think about, and what do you tell them they can and that they cannot do?
Well, in this context, it's probably it's a question probably of leveraging the right approach, applying the right workflows and the appropriate tools, and each playing a very important role in tackling the data privacy challenge. And depending on the procedure and technology and communication challenges, you must also consider which stakeholders need to be involved, which stakeholders need to be considered. I think that's key. Who informs who, by when, and what role do employees have? I think the process around it, and keep it really really clean and transparent is very important. Yeah, so you need to talk or you need to take on board the data protection guys, the data security guys. You need to engage with IT, employee representatives, the legal department if it exists. Yeah, and a very major thing in Germany. Yeah, you were talking about a big German company where some US folks want to do investigations, and what we have very strong here you can actually have it starting with the employees, I think from 10 employees on, is the work council. Yeah, the work council is a shop floor organization in many European countries that represents workers and functions as a local or firm level complement to trade unions. Yeah, so that's I think a very clean process. Yeah, and involving the right stakeholders is very, very key to what you're doing here and what you can achieve.
So does that mean that as a first step, someone trying to get information out of a German company has to, in some fashion, communicate with and work with the work council?
As well, yeah. I mean, they are part of it. Yeah, I think the stakeholders I mentioned, the parties I mentioned, I think they are, in my opinion, the most important. There might be some which I have not mentioned yet, but I think that's the key stakeholders, and the work council for sure. Yeah, because they sit on the data, they sit on PII and make sure that the company is only keeping the right records in the right way, and only one file per employee and all these things. So they are a bit like, no, probably that's wrong when I say it, but sometimes it appears to me like the regulators in the within a company.
So they have a role in saying, yes, you may have access to this data, and no, you may not have access to that data.
Yeah.
And then, so that's access to data, but then the data can't just go anywhere. So if they said, yes, you can have access to the following 10 or 100 or 100,000 files, that doesn't mean, does it, that someone can load those files onto a hard drive and ship that hard drive back to the US?
No.
So what does have to happen then?
No, sorry for this very bold answer. In Germany, we mostly rely on in-country processing and hosting, along with pre-filtering, to definitely exclude a data privacy violation transfer to a third country. So I think that's what we need to do. Yeah, you cannot just say, here is the 4 terabyte or whatever amount of data, and ship it to the US or wherever it's supposed to be investigated. That's impossible. Yeah. So we need pre-filtering and processing before we give anything out here of the country. if that makes sense.
Yes, it does. Does that processing, where can that processing take place in country? Does it have to be on a server sitting in someone's office? Could it be in a cloud where the infrastructure all is within Germany? What are the possibilities and the limitations?
Well, on-prem obviously is always is probably always very easy, to process the data on-prem because it's on-prem. Let's not talk about security, but on-prem is on-prem. But if you go to the cloud, which is, I think, from a commercial perspective, is probably a bit more, how can I say, more advantageous for companies. Then it depends, where's the data center, where the data will be processed. And the other thing is obviously who can access the data from where. Because that it can't be that we do all this, all this cautious of processing and pre-filtering the data within Germany or Switzerland, and then we have a possibility of a US entity accessing the data and do with it whatever, maybe monitored, but being able to access it. So that should be clear that this is not possible. Yeah.
So does that mean at a practical level that cloud options are rarely used in this context, or do people figure out how to make it work?
I think it's a bit of both. It depends a bit on the, let's say, on the structure of the organization. Historically, law firms, for example, they tend to avoid the cloud where they can, just to make sure that they're on the safe side, because on-prem they have always been on the safe side. And I mean, they have opened the law in such a way that they can actually do what is social adequate, but this is not defined what is social adequate. So this is this side. And some obviously also go to the cloud because commercially, like I said, it's more beneficial to do it on a cloud service rather than having your whatever relativity, for example, installed on-prem, because also the vendor strategy goes into direction cloud, I think they won't make it. Well, how can I say? They probably won't make it too attractive for you if you want to have your instance on-prem, and it's also from a from an update perspective and so on. For vendors, it's much more. It's not cloud. It's difficult, to be always up to date with the software. But there's a mix. Some go to the cloud if they know the data is kept within Germany and won't leave the country and won't be accessible, and others go the safe way because they knew on-prem always worked.
Once the data has been processed, then it needs some culling and filtering and evaluation. That activity also all has to happen in country, right? It's got to take place in Germany.
Yes. Before you, then let's go back to your case. There's this American law firm, I think you used as an example, investigating in a German company. Before the data will leave the country, anyhow, this all needs to happen within Germany, so that when you ship it, you're sure you have not shipped anything to the US, which you should suppose not to ship. But at this stage, I mean, when we're talking about cloud and leveraging global active learning models, I would like to ask you a question, if I may.
Of course.
I know that's mine too, but this is something which is always playing on my mind. And to understand what is your vision and our idea of leveraging global active learning models that respect local data privacy restrictions. It's a tricky one, isn't it?
It is a tricky one. And I think that in that situation, it really requires taking a close look at how the technology operates, what it enables and what it doesn't enable. Is there, for example, the ability to construct an active learning model? So an artificial intelligence, AI-driven learning model that you can use where you draw upon what's been learned earlier, but where you don't transfer the data where the information was learned from. So if I'm going to create a model, so I'll answer it a little differently. Imagine that you've created a model and you've used that model to find data. And you then send the data to me, and I'm in the US. I might be concerned that I got the data from you, but I really don't have an understanding about how you got there. Because you just tell me I used an AI model, and I go, well, AI model, what's that mean? What did you do? What are your search terms? And of course, there aren't search terms. So then the question becomes, are there ways to do two things? One is to explain the process followed in a way so that ultimately, if necessary, it can be explained to someone with no real expertise in this arena, such as a judge who probably doesn't understand how any of this works. And then second, is there a way of passing along enough information? So it's not just a general explanation, but you can say these are the factors that the model considered. These are the weights that it placed on different things. Can that information be brought along without also bringing along your name? You know, someone's email address, their street number, some sort of, we've got social security numbers, you've got comparable identification numbers without bringing those numbers along. If the model allows for that, then you should be in good shape. If the model requires that information to come along, well, now we've got a problem. And so it's learning what the technology is, just trying to get a better understanding of how the technology functions and what information comes along when everything gets transferred over. Does that make sense?
That absolutely makes sense. And also, I mean, that makes me also think that it's important that as a service provider in e-discovery, that you should always have the option probably of different technologies, or depending on the case you have in front of you, right?
Right. At a minimum, you want, if you're using one primary technology, you want to have a good understanding of how that technology works.
Yeah.
And if it's not capable of delivering what you were just asking for there, then you better have a fallback plan.
Yeah.
Because if I, sitting in the US, tell you I want you to use a specific technology to do the active learning, supervised active learning, supervised machine learning. And if you then take a look at that technology and tell me, sorry, no go, because it doesn't prevent conveyance of the information that should never leave Germany, then we've got a problem. So if the primary platform I use doesn't have those capabilities, I better have a secondary one available, or else forget about getting data out of Germany where a machine learning model has been used, right?
Yeah. Yeah, but this is, I think this is only one of the cases I can think of, yeah, because I think also in early case assessment, I think that's important. Or I mean, if you think nowadays, coming back to the 4 terabyte of data, and if you think it's still acceptable that you you take 3 weeks to ingest or to process the data, and then you get another 20 reviewers wherever in India, and then after 4 weeks you can give like a rough idea where the direction is going. I think that's not feasible anymore, and I think that law firms or other service providers, they can really differentiate with and understanding early case assessment.
Mm-hmm. So I think that to your question then, I think that what folks in your situation, so you're sitting in Germany, you're the ones who are going to have to process the data or work with a German-based provider with a presence in Germany. You have to process the data. You've got to filter and cull through and search through that data. The more that you have tools that let you quickly start working with that data, as opposed to a setup that is going to take, as what did you say, a cumulative 6 weeks before you see anything?
Yeah.
For whatever it might be, the more you have tools that let you apply models against the data right away, that let you use TAR, predictive coding, or whatever you want to call it, supervised machine learning capabilities to look for something and then find more like that, the more that lets you search for concepts within the data and expand that search and do it all locally, on-prem if necessary, the better placed you are to be able to quickly start getting an appropriate set of data back to the people outside of Germany. But if you've got to rely on the more traditional approaches, at least what I've seen in the past, and I imagine you've seen the same thing, everybody's stress level rises because it takes so long. People get frustrated. Communications back and forth are challenging.
Yeah. And I think that's, I mean, and to my experience, and I think there needs to be like a little bit of a shift in this industry, because a lot of vendors, I think, have been, they have been certified in a certain tool or maybe two. I think what I've seen very often is that, taking REL for the dirty stuff, let's say for the fur, and then for a nicer visualization and deeper analytics, you pump it then over into Brainspace, and also to have the communication with your client about it. But I think in terms of really understanding the case at a very early stage, it doesn't necessarily have to be only like this.
Right.
Take the 4 terabyte and run it through relativity first, then to go into deeper analysis. I think that can also be, choosing using the right tool at the right stage and where needed, and depending on, also on the requirements of the client, really.
And depending upon what tools you have available to you, you can also, I think, start evaluating that data before putting it over in for a more traditional review process. So rather than having to put it into the review platform first, a review platform first, and then take some portion of that data and put it into yet another tool, you can start right away with some of the tools that let you do that type of visual analysis and those other capabilities. So turning the process on its head a little bit. I think, I mean, I know when I've done that in the past, I've found that to be very helpful. And I haven't dealt so much with data in Germany, or I haven't for a long time. I've dealt more recently with data in Switzerland, and no one was going to let me see anything until the rest of all of this was taken care of. So the challenge was, how do we get stuff taken care of quickly enough so that I can in turn get something to get onto the law firm?
Yeah, I mean, in Switzerland, it's I think also with the special banking regulations that's probably even more challenging. But I mean, obviously in my daily life, I'm not only focusing, on the on discovery processes as a regional technology director. Obviously, there's a lot of technologies around me and with me, but it doesn't matter what type of project or matter the lawyers have to run. Something which we, for example, at Clifford Chance really emphasize as part of our strategy is exactly that. But it's not only discovery software, is embracing the right technology for increased efficiency and effectiveness in the delivery of the matter. So, and that could be anything. That could be like a collaboration platform. There could be other tools which help to move the stuff forward much more efficient and effective. The matter. So I think there's also, in my world, there's also other areas where embracing the right technology can really help to make a difference, for your client.
Yeah, because I am sure that your clients are like all of our clients. They'd rather not pay bills they don't have to pay. They'd like to get matters taken care of generally sooner rather than later, less expensively rather than more expensively, and they're hoping you can be more effective and efficient as you do it.
Yeah, absolutely. And there's in our global legal tech consortium, there are we discussing a lot of things. And just yesterday we were discussing alternative fee arrangements. And that's an interesting discussion, because this is really a worldwide forum. And I brought into the equation to understand the data you possess, and then come up with some alternative fee arrangements, which I think was not so known to everyone. But I think an absolute interesting point to get a deeper understanding of the work you have delivered in a certain type of matter, and go into data science and analyze all the data you have about your matter. Not just the time entries into your practice management system. So I really get a complete overview. So
And that is, I think, an emerging area. I know there's been discussion for as long as I can remember about alternative fee arrangements, but very little action on that front. And I think very little discussion until recently about what you were just talking about, which is actually taking a look at some of the data to figure out what to do instead of doing something and then looking at the data.
Yeah, exactly. I mean, that's what I found really interesting, a general counsel of a big energy company said recently on an event, so it's not that recently, because obviously we all haven't been to events.
Hold a second while I let the dog out the door.
Okay. Oh.
There we go. Sorry about that. So go ahead.
No problem. I'm always going along with the sun, so it doesn't disturb so much. We will see this on the video as well. But she was saying, in terms of alternative fee arrangements, she was saying, like, I'm not interested in freebies and getting more for less. I want a partner in in the matter, who comes up with some innovative idea how we can work together or collaborate together on a different basis than an hourly rate. Yeah, and I think that was a good statement and a very positive statement, because she didn't say, I want the valuable work you do for less money. She said,
Right.
I just want,
Well,
some
she wants the
value in the
yeah.
transparency.
Right, and the interests aligned so that you
Yeah.
have the same interest in getting something done that she does,
Yeah.
which is going to be a continuing challenge. And I look forward to hearing what sort of success you have in accomplishing that. Thanks, Christiana. Let's see if I get the pronunciation correctly.
Perfect.
Christiane Müller-Haye. Close enough?
Müller-Haye, but that's
Müller-Haye,
fine.
Christiane
Yeah.
Müller-Haye is a regional technology director, or the regional technology director, Continental Europe at Clifford Chance in Frankfurt. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. Thanks for joining us today. And for our audience, please join us again next week for another episode of eDiscovery Leaders Live. Thanks so much.
Thank you for having me. Thanks, George.